I'm going to address three issues. The first one has to do with bank charges. The second will be the economy as a whole. And the third will be to address the issue of the questions that have been raised by me in Parliament on the Petrocarib Fund and the inadequacy of the responses that we received in the House last week. We believe that the committee's work should take a careful look at that section, 132, and to see whether the Code of Conduct, as is proposed, really will have the teeth that can allow a fair governance of the question of bank charges. My own position has been clear that there should be some kind of regulatory framework that ought to be considered that is more specific, as I said in Parliament last week, that should become part of the regulations of the supervisor in relation to creating a regulatory framework within which the question of bank charges can operate. It doesn't mean that we are proposing that the banks, that the regulator must set the rate, but that we should consider that there is a clearly defined regulatory framework within which a transparent and consistent methodology can be developed for the issue of bank charges to be fair and equitable to all. I asked about a risk analysis. Has it been done? Yes. I said, was it favorable? Was it unfavorable? What are the conclusions of the risk assessment with regards to the sustainability of the fund? Those are my questions. No attempt was made by the Minister of Finance to answer my question in relation to that risk analysis. Instead, we were told that the risk assessment process was aborted due to the bona fides of the consultant and possible copyright infringement. That's all that was said. They went on. All reports that had been issued to the fund by the consultant were to be retrieved from senior managers. That means that they're not retrieved yet. Were to be retrieved from senior managers and filed. And they suggested that the assessment provided by the consultant has not been adopted. Now, my question is, why hasn't the assessment not been adopted? My further question is, it was the board's decision to employ this consultant. Presumably, there was some kind of a procurement system that was employed in order to get that consultant on board. And I would assume that appropriate due diligence should have been done before accepting that consultant. It just leads me to ask the question. You didn't like the conclusions of the report that were presented and the recommendations of the consultant. So was that then the basis on which you sought to discredit the work of the consultant? These are very, very important issues. This is not a personal, private matter between me and the minister, as suggested by the former minister, Dr. Davis. No. This is government business. This is public business. This is $3 billion United States dollars worth of business. This is not something for Dr. Phillips and I to have a private conversation in a back room about. This is serious business. So the questions we want answered, and which must be made public, are what caused the initial decision to be made by the Petrocarib Fund to have the risk analysis done? First question. The second one, what was the due diligence carried out in appointing the consultant? Third question, what were the conclusions of the report of the consultant? And what was the response of the Petrocarib Development Management to the report? We need to get all of these questions answered. We need absolute transparency on it, and I intend to use the floor of Parliament. I intend to use the avenues of the Access to Information Act and any other means to ensure that we have absolute transparency in this matter. Thank you very much.